Posted by you/need to exit. I need to exit my business, but my partner is being unresponsive. What's the best strategy? Hi smart legal people. A few years ago, I became a partial owner in an online business that my friend started. We are a multi-member LLC, taxed like a partnership, in Oregon. I and one other partner own 20% each, and the guy who started the business owns 60%. For a number of reasons, I need to exit this business and move on with my life. We do not have an operating agreement. I know that's stupid, please don't beat me up about it. I tried hard for a long time to get everyone to sign on to one, but it never got done. I gave notice to both partners that I intend to exit about 2 weeks ago. The minor partner has accepted that, and we are working on a transition plan. The major partner, so far, has not responded to any communication. I assume he's frustrated and not ready to talk. All communication has been by email because we travel frequently and run the business remotely. Because he's a friend and I care about the success of the business, I plan to continue to try to engage him and structure my exit in a way that is fair to the business and my partners. My question: what do I need to be doing right now to make sure I cover all my own bases and do this right, considering that my partner is being unresponsive? Do I need to be sending certified mail, or is email good enough? Email with read receipt? Something else? What kind of timeline should I be operating on? I have many more questions, actually, but I'm trying not to think too far ahead and take this one step at a time. The research I've done so far leads me to believe that, in Oregon, LLC members can remove themselves from a business 6 months after giving notice, but still retain economic interest in that business. Sort of like a last-ditch way to make an exit when agreements simply can't be reached otherwise. I've worked really hard on this business, and it's mildly successful, more than $100,000 annual profit. It's important to me that I protect my own rights, economically, while exiting the business in an upstanding way. There are probably a million ways this can go, and who knows what will happen next week, but what should my next steps be? Thanks in advance. P.S. I expect this to take some time to resolve, so I look forward to posting updates and continuing through the whole process here. Now on to some comments. Posted by Behold My Cape. Hire an attorney experienced in small business law in the state of Oregon to help you sort this out, is what your next step should be. OP responded with, thanks. If I don't make any headway in negotiation with my partners, I will definitely do that. Perhaps I need to set a deadline with myself for when it is time to go that route. I'm hoping, in the meantime, our/legal advice might be able to give me some pointers to put myself in the best position going forward. Perhaps you could give me some advice on how to find the type of lawyer you recommend. I'm not even sure how to find one. Posted by Deleted. What/you/Behold My Cape said. Your issue is a lot more complicated than can be answered on this subreddit. OP responded with, maybe you can help me by pointing out the specific complications you see that prevent you from giving advice. I probably don't even see many of them. I don't know what I don't know, so they say. Posted by Dachinian. I would give it more time and keep trying to get in contact with the major partner for now. As you said, you all travel a lot. Is the other minor partner willing to buy out your share? OP responded with, I certainly will. We all travel but are active with communication. My major partner is responding to other business-related emails, but not this specific line of communication. I feel like he's just selectively ignoring it. Buyout by the other minor partner. I'm not sure. I'll bring it up with them, but I don't anticipate they have the cash on hand to make a reasonable offer. Perhaps there are creative ways to finance that, though, if they're interested. Update: can I sue my asshole business partner in small claims to force him to make distributions to me? Oregon. First, a quick update. I hired a non-litigation business attorney to help me figure out what my rights as an owner were. He was helpful, but that didn't go anywhere. My non-responsive partner finally contacted me after months of silent treatment while I continued to run the business, and the results were disappointing. A few weeks ago, he decided I'm no longer involved in the business, removed me from our bank account, stopped making distributions, and sent me a generous contract offering the opportunity to return my equity in exchange for not suing me for something. His threats were vague. Now, on to the show. So, now I've hired a litigation attorney who's the best, and most expensive, in town. I'll ultimately be following his advice, but I had an idea I thought I'd flesh out here before passing it by him in case it saves me some time, money, discussing hypotheticals with him. It is assumed that, as long as my partner doesn't buy me out, I am due my pro rata shares of distributions any time they are made to other partners, and I am not obligated to provide any further service to the business. Buyout talks are going nowhere right now, so my thought is, can I just wait for them to make a distribution to themselves and then sue them in small claims to recover my share? Seems like it could be an easy way to make myself whole one little bit at a time and, perhaps, motivate him to have a more honest buyout discussion. It's unlikely my share of any distribution would be over the small claims cap, $10,000. Is this a decent idea for a remedy? If so, who would I name as defendants? The company? My two partners? All of the above? And how will I know if a distribution is made in the first place now that I've been removed from the bank account? I know I'm entitled to inspect company documents, but not sure what I would ask for in this situation or if I could believe the accounting records that are sent. Now on to some comments. Posted by Oregon_guy. Why would he make distributions, knowing that you are entitled to a portion? If he wants to lock you out of distributions, he'll just pay himself wages. OP responded with, a consideration, yes. If he did that, though, it would only be as retaliation. Our course of performance has never included salaries, which I think would probably leave me with some other civil remedy. Obviously not small claims, though. Posted by Deleted. It is assumed that, as long as my partner doesn't buy me out, I am due my pro rata shares of distributions any time they are made to other partners, and I am not obligated to provide any further service to the business. Edit, I see you don't have an operating agreement. In the future, businesses aren't formed unless operating agreements are signed and those agreements clearly articulate valuation, forceful buyout, death, divorce, drug abuse, disinterest, lack of effort, and audit rights. I think you randomly filing a small claims court suit over $10,000 to put pressure on your partner may bar your larger lawsuit from proceeding. It may kill your ability to do anything about past actions, all in the name of a not-so-wise litigation strategy. I am confused on how your name was removed from the bank account, since you didn't consent. The problem is you don't have a membership agreement, so the person's ability to change bank accounts is likely pretty close to unlimited. OP responded with, in the future, businesses aren't formed unless operating agreements are signed. Don't I know it? In an interesting twist, we made a document request for some initial discovery, and they, partner/partner's lawyer, returned an unsigned operating agreement, one I had proposed at the beginning of our venture, but he rejected. May bar your larger lawsuit from proceeding. Interesting. Thanks for the thought. I am confused on how your name was removed from the bank account. Me too, to be honest. Lawyer says it doesn't really matter. Sure, feels like it does, but I trust he knows better. Posted by Zomgleegs. If you were my client, I would kill you. Why? 1. Things said in the lawsuit can be used against you later. 2. Decisions made in the lawsuit can be used against you later. 3. You win more than $10,000? It's reduced to $10,000 and you lose the excess because of the small claims cap. 4. Depending on your state/type of claim, you lose factually related claims if you fail to bring them in the same lawsuit. Do not do anything without clearing it, in detail, with your attorney. OP responded with, thanks. Those things definitely go in the minus column on the T chart. But don't worry, I won't be making any decisions without counsel. Update plus question, can I sue my asshole business partner in small claims? This is in Oregon. Hey folks.
You may know me from my earlier, unpopular, threads like A. I need to exit my business, but my partner is being unresponsive.
What's the best strategy? B. Denied counsel by 2 lawyers for conflict of interest, and C. Can I sue my asshole business partner in small claims to force him to make distributions to me? I have a lawyer, 2 of them actually, and I listen to them and do as they tell me. I come here because I'm slightly neurotic, and being neurotic with your lawyer is not a financially sound practice. Today, I have a brief update and another question. First, the update to entertain. For the last 8 months, my lawyer has been hounding the business lawyer for the financial records I'm entitled to have access to, and we were either led on only to receive nothing after many promises to deliver or stonewalled altogether. Finally, in November, we filed suit against the business in Big Boy Court to receive injunctive relief, requesting the business records and legal fees, which we believe were due under Oregon law. The registered agent, my biz partner, evaded service until January. Then, We received no answer to the suit until the day after we filed notice of intent to take default. The answer was filed by a different lawyer, same firm, denying all allegations and claiming I do not actually have interest in the business. They also got in touch, a third lawyer, again, same firm, at the same time saying, "Let's talk. What do you want?" We said, "We want to be bought out." They asked, "Okay, how much?" We said, "Send the damn records over so we can tell you." They said, "Okay. Give us 2 days. We have them, but our admin needs to label them." They're running 2 different storylines, one officially in the lawsuit, and another in what at least felt like an attempt to negotiate. That was 2 weeks ago. We've been hounding them again and are being stonewalled again. Based on the history of this case and my long-standing relationship with my partner, I'm no longer convinced they intend to negotiate at all, and our conversations so far are really just another attempt to delay. This morning, it was uncovered that the business has altered some, official documents to be very much not in my favor. My lawyers are friggin' pissed and we're scheduled to chat next week about potentially moving to a contingency agreement. Which brings me to my question. What do I need to think about before accepting a contingency agreement? I know the most basic things to think about: ultimate value of case, cost to pursue, and contingency fee. But I really don't know anything else. Are there other factors to consider? I feel like being offered contingency is a godsend for most because it removes the uncertainty of the cost of litigation. That's enticing for me as well, but I'm also not destitute and, so far, I've been pretty happy with how efficient my lawyers have operated. I feel like it's not a tremendous hardship for me to keep funding the operation. At least for now. And keep all the, still uncertain, spoils. Any advice on how to approach this? Now on to some comments. Posted by Jippin. Get the altered documents submitted to the court, then raise it to the judge and the bar to file criminal charges. Faking evidence is a big no-no and can get the opposing counsel disbarred and arrested. Also, you have a bloody lawyer. Ask them. If you feel like they're doing a shit job, get another lawyer. OP responded with, "Like I said, I'm happy with my lawyers. They're performing very well for me. My question is about what to consider when going contingency versus self-funding the litigation." Posted by One Neve. Considering how much the opposing party has been trying to delay things, you can probably expect them to continue to use the same tactic going forward. Each delay will add on to your legal fees if paying by the hour. I know there are lawyers out there who try to exhaust their opponent's bank accounts using that method so that they win by default. Your attorneys also seem like good people, and they may also be offering to work on contingency as a favor to you. On contingency, the attorney typically takes 30 to 40% of what they get for you. I see 40% mentioned more often than less. How much do you expect to get from your 20% share of the business? Based on a quick Google search, in 2013, the median litigation cost through trial for a contract case was $91,000. Page 7, since you hired a litigation attorney who's the best, and most expensive, in town, your attorney bill could end up costing more than usual, too. The likelihood of your business partner settling versus the likelihood of having to get a judge to force their hand might also factor into which option you choose, since legal costs would be lower with a settlement instead of a trial. So based on what you know about your case and the information in the preceding paragraphs and what you talk about with your attorneys next week, you ought to be able to make a reasonable cost-benefit analysis of the 2 options on your own. Without knowing more, I don't think anyone here can tell you which option is better for you. OP responded with, "Wow, thanks. That was very helpful. Since the beginning, I have believed, on the advice of my lawyer, that my case is probably worth somewhere around $100,000. I've been optimistic about that, but the lawyer has been reminding me that litigation is really expensive and that there's actually not enough on the table for either side to sanely take this all the way to trial. The fact that they're now considering taking the case on contingency tells me something must have fundamentally changed about their confidence in the case. That's great, and I guess I'll learn more next week. And yes, my lawyer is really expensive, to me, anyway, but since the suit was filed, most work has been done by another lawyer in the office who's also very good and has much more palatable hourly fee. I've actually been surprised by how well they've done at keeping down the hourly billings. Very efficient. They also specialize in my type of suit, shareholder oppression stuff, so they are probably uniquely positioned to run the suit in the best and most efficient way. Final update, Oregon. Can I sue my business partner in small claims court? Hello again, r/legal advice. I understand you appreciate updates. I posted several questions and updates throughout my saga, but here is the most relevant up. The important points. 1. I was a minority shareholder in a small business in Oregon. 2. I also worked in that business. 3. I decided I wanted to no longer work in the business. 4. The majority owner decided he didn't like that, so he fired me instead, froze me out of the bank accounts, stopped my distributions, and threatened to sue me to get back all the money I ever received from the business. That was scary and frustrating, so I got a lawyer. Now the update. After spending months trying to peacefully resolve everything and getting stonewalled, we filed a document inspection lawsuit in November to compel my partner to produce all our agreements and financial documents so we could at least understand what the heck he was doing and to figure out just how bad he was screwing me. My lawyer, who's practiced for 30 plus years, said he's never had to file an inspection suit before because, in Oregon, it comes with attorney fees. No one allows themselves to be sued for that because it's a big liability. My partner dodged service for 2 months, so we weren't able to get the ball rolling until January. He had a lawyer this whole time, but they never agreed to accept service. And then, more stonewalling. We ended up filing notice of intent to take default. The next day, they filed an answer to the suit denying everything and countersuing for attorney fees, which, apparently, they can't actually get. In March, my lawyer's assistant was doing some routine research and just happened to find that the business filed amended documents with the state that completely omitted me as a owner. He was trying to erase me. My lawyer decided the best thing to do was to continue the inspection suit and file a new suit naming my partner personally for breach of fiduciary duty. That way, he could try to do as much useful discovery as possible under the inspection suit where we could get attorney fees back and use all that discovery again in the individual suit where we couldn't. This is also the point at which he offered to represent me on contingency, which was a huge relief for me because he's expensive and things were escalating. He also credited the fees I'd already paid towards future costs/expenses, which helped a lot. Even though the other side was making no effort to resolve the problem, that really felt like a positive turning point because I think getting a lawyer on contingency for a business contract dispute is pretty unusual. I later learned my lawyer offered contingency because my partner pissed him off and he wanted to keep turning the screws on him. He didn't want me to bail. I get the impression he's getting towards the end of his career and just likes to work on cases that interest him now. Fast forward a few months, and we depose my partner. That experience pissed my lawyer off even more. I wasn't there, but reading the transcript was both sad and hilarious. My lawyer said it was the third most frustrating deposition he's ever taken. Oh well, guess you can't be first at everything. After the deposition, partner's attorney got in touch to offer a settlement. He was on his third lawyer at this point, BTW. It was a terrible offer, so we said, no thanks, but we'll do mediation if you want. They agreed, which is tragically comical to me. Mediation was my partner's idea that I agreed to before any of this insanity ever started. But he changed his mind at the last minute and I never heard from him again. We spent a full day in mediation and, at the end, accepted a mediated settlement when negotiations broke down. The settlement, once the contingency fee was subtracted, was not far from what I thought I was owed, so I was happy to accept it and put an end to an emotionally draining 2-year saga. I often second-guessed myself throughout this process and felt guilty for suing someone I once cared so much about, but, really, he brought it upon himself. And I'm happy that I stood up for myself and am not spending the rest of my life asking, why did I let him get away with that? My ex-partner has a very strong cult of personality that served him well. He's very charming and can convince most people to do what he wants. I don't think anyone's ever stood up to him like that before, and it caught him flat-footed. The whole process was confusing because he never made a logical move until he was truly backed into a corner and was facing trial. At every turn, I wondered, is this a trap? Do they have some epic strategy I can't see? The longer things dragged on, the more I realized they didn't. There was no strategy beyond ignoring me until they couldn't anymore. Though my bank account is much healthier today, I have to say the money really rings hollow. I lost a friend and a partner in this debacle. But it was obvious I was going to lose that anyway, so better to have the money than not have it, I guess. And I'm very thankful I found the lawyer I did. I probably could not have sustained the fight all the way through trial without a contingency agreement. I could tell he really loved his job and I think he's a little bummed we're not going to trial.